Hello everyone, so welcome back to my English law channel. So this is about tort, an introduction to tort. So tort comes from the French word wrong, for wrong, so it's T-O-R-T. When I first heard tort, I thought it was the past tense of teach, but it's pronounced almost the same. It's a type of civil law as it's not a criminal law. Therefore, remedies here are about paying compensation or giving property or something like that, or retracting a statement. If you've infringed someone's personal interest, if you've committed a tortious action, you're a tortfeasor. There can be tortious malfeasance. So it's about injury or loss or damaging somebody's interests. Sometimes there's the duty or an obligation, and a defendant is in breach of that, and harm results. So the police are not involved in this. People are not being arrested, although you can actually take out an action in tort against the police. Anyway, there are lots of different torts which could be committed. These could be negligence, it could be nuisance, it could be trespass of the person, it could be defamation, which is to say lying in a way that ruins somebody's reputation. You could be interfering with someone's physical integrity or someone's property interests. You could be harming a person's economic interests. Any of these would be tortious. So there's certain interests which are protected under law, under the law of tort. About physical integrity, which I mentioned. It could be public nuisance, trespass to the person. There are various interests in tort about negligence, private and public nuisance, trespass to land. There's always intellectual property. Any film or book you've written, music you've written, even a chemical formula that you've patented, anything like that. The use and enjoyment of land, these are protectable under tort. Your reputation, as I said, that's under the tort of defamation. If somebody is disseminating foul legends about you in order to give you a bad name, even though they don't say it outright, if they say it impliedly, that can be sufficient. Lady Sally Bercow, the wife of the Quondam Speaker of the House of Commons, she said, why is Lord McAlpine's face just trending today? Innocent face. She wrote that as a tweet, and that tweet was sufficient for a tort action against her. I felt too harsh, actually. It was too harsh, actually. I can repeat that now because Lord Alpine has been called to his reward, and you cannot launch a defamation action on behalf of the deceased. Okay, there's also privacy. If someone breaches your privacy, then this could be a tort, especially if there's a misuse of private information. So tort is about protecting various interests from interference, and compensations are awarded, damages are given if someone has wrongfully harmed you. Now, courts sometimes order someone to cease and desist from committing a wrongful action, such as indirect interference, which unreasonably impairs your enjoyment or usage of land, or causing some sort of nuisance. The court order is given to the defendant as an injunction, and these are usually in a case of nuisance. And for example, if someone like Boris Johnson, he wanted to prevent a newspaper publishing the fact that he had a child with his mistress when he was married, but he failed to get the injunction there. So the courts are rightfully reluctant to grant injunctions about that. The court refused to say, well, the matter of a child's birth is a matter of public record, and no, it's not going to be kept secret. I mean, you find this embarrassing that your adultery is publicised. Well, you shouldn't have committed adultery. The public has a right to know. Anyway, there was no reason to abridge the liberty of the press over that one. So the law of tort doesn't protect every interest. There are some situations which loss or harm arises from a person's behaviour, and there's no right to sue is consequent upon that. For instance, there's the principle of damnum sine injuria, as in damage without injury. Bradford Corporation against Pickles, 1895, was a case in point, where Pickles, he owned some land, and some water from that flowed into a river which was used to provide water for the people of the city of Bradford, and he offered to sell this land for way over the odds to the city. The city father said, no way, that's too expensive. All right then, so he took some action which diverted the course of the water, and there wasn't enough water supply for the city. So Bradford took action against Mr. Pickles, but the House of Lords, which was then effectively the Supreme Court, ruled in favour of Bradford. They held that the defendant had committed no damnum, no damage. So the city had suffered damage, but it wasn't an injury, if you see what I mean, because it was that the water wasn't a stream as such, so he hadn't broken any law, civil or criminal, so they could do nothing. They could have bought the land when they wanted to. They didn't have a right to that water as such. In fact, so they should have, paid over the odds for it. Seems rather immoral what he was doing, but it wasn't certainly not illegal. Okay, so how about the fault here? So usually there you have to be some fault, but there are some no-fault torts. So there usually has to be intentional carelessness on behalf of the defendant in order for him or her to be found liable. So carelessness is the main kind. If you do something recklessly or if you're negligent, then you will have liability. So the Consumer Protection Act in 1987, and that introduced strict liability for products which were substandard if personal injury results or indeed damage to property. So personal injury has injury of the human body. Okay, so anyway, the person who is moving the action does not have to demonstrate that there was any fault on behalf of the person who manufactured the product. So what are the purposes of tort? Well, the principal one is that tort is to give the claimant who's been injured some pecuniary compensation. And there are two ways to do this. One is shifting loss, the other one is spreading loss. So shifting loss is when the innocent claimant, the loss is shifted onto the defendant who has caused the harm. The other one is loss spreading, that is diffusing the loss throughout the whole community. It's distributive. And that's why we have compulsory insurance. So there was a scholar, Tony Weir, in his casebook on tort. He said the following: the plaintiff is asking for money damages. Generally, he's been hurt in one way or another and is claiming compensation for harm suffered. Sometimes with the extra if the defendant has behaved very badly, though occasionally and increasingly he is more intent on vindication or explanation than compensation. So I'll skip on. Anyway, so there are also particular states of mind which relate to malice, intention, and negligence. So sometimes no state of mind is required to be there. It's a strict liability offence. It's a little bit akin to mens rea in criminal law, though I must triply underscore the fact that tort is not criminous law. It's civil. When I say civil law, I don't mean Roman law, I mean non-criminal. So anyway, so there's got to be justice here. We must realise that if wrong has been done, this must be set right by the judicial system. So compensation of a pecuniary nature is the chief function of the courts here. Also, but there also is to dissuade people from doing something actually or potentially tortious. So the notion you might have to pay heavy compensation has a dissuasive effect on many would-be tortfeasors, and therefore fewer torts are committed. There's less harm to the community. So retribution is said to be a less important one. So remember, it does have certain things in common with criminal law, though it definitely isn't criminal law. So tort law is also comparable in some parts to contract law, because there are certain obligations, but well, you have to try and we know that contract law is enforcing promises, but in tort this is a bit different because you've not usually made a promise as such. So this torturous obligation is set by law, not an individual contract negotiated. If somebody is driving and knocks somebody down, then that person has to pay compensation and may well be guilty of a crime as well, because remember, you're legally bound to drive with reasonable care and attention. So in a contract, obviously the parties hammer out for themselves what the terms are going to be, and the law doesn't usually set those terms of contracts. So a breach of contract means that someone is in breach of his or her obligations, which have been freely agreed to. Okay, so how about tort and criminal? Well, where's the crossover and where's the difference? So we know that a crime is offence against the whole of society, not just against an individual. Even if only one person is harmed, it's up to society to take action. Even if the so-called victim doesn't want to take action, no, the police and the courts would step in. So here we think this is a breach of the law which is so grave that the state must sanction it, possibly with life imprisonment without the possibility of parole. That's the harshest sentence permitted by law. Tort is different because this is not being penalising people, and it's not about public interest. Usually it's more about the individual. It's up to the individual to take action, though yes, public bodies can sometimes take out an action in tort. So criminal law and tort, they are both trying to govern behaviour by setting a minimum standard of behaviour. But this is how tort is different from criminal law, because tort is not about introducing abstract standards. Liability in tort is usually consequent on proving that some damage has occurred. So there has to be some sort of chain of causation. There can be novus actus interveniens to disrupt the chain of causation. Someone who is driving in a crapulous state is not liable in the tort of negligence, but they might be liable in tort of negligence if then they cause damage as such. So without damage, the driving under the influence of alcohol is a criminal act, but not a tortious act. But obviously, the same action can be criminous and tortious. All right, damage. So in many tort actions, you have to prove to the court that damage has occurred before there can be an action, and then the court has to decide which losses are recoverable and which ones are irrecoverable. There are certain laws about recoverability. And remember, because this is civil law, not criminal law, the standard of proof is lower. Have to prove on the balance of probabilities, not beyond all reasonable doubt, as in balance probabilities just over 50%. People who take actions against the police for, say, wrongful arrest, or obviously, false arrest is a crime, even if the police do it. But that's virtually impossible to succeed. The police didn't even have a reasonable suspicion. Their suspicion might turn out to be wrong, but so long as it's reasonable, then they're not guilty. But if you try and tort, you have a much better chance, because you only have to prove like sort of 51% likelihood that you'll win, in which case you'll be paid compensation. Whereas you want to prove it to the criminal standard, we're talking about something like 99% sure. Okay, so what was I going to say? So some things are irrecoverable because the damage is too remote. There are rules on remoteness. So sometimes some behavior can be actionable even though no damage is consequent from it. There are situations where there's intentional or negligent conduct and it's actionable. So sometimes the claimant's rights have been impaired, and he doesn't need to show that the damage has resulted. For instance, there are subject to lots of defences. It's a tortious action to touch another person without his or her permission. That's called trespass of the person, even though no damage arises. But of course, there are plenty of defences of just accidentally bumping into people in the street, reasonable social conduct like tapping someone on the shoulder, or touching someone's hand with a handshake who doesn't want to shake hands. Okay, because de minimis non curat lex, that well-known brocard. So after Burchard, the 11th century Bishop of Worms, who came up with so many of these legal maxims, even though it's a Roman law system in Germany, Burchard's brocards are applicable in common law. Remember, you have your interests, which include your reputation, and if someone goes around telling foul lies about you or implicitly saying terrible things about you, then your name has been dragged through the mire, and you can take action about that. The person must cease and desist, must obviously publish a retraction and an apology with equal prominence to which the defamatory statement was made, and indeed pay compensation, which is monetary. Anyway, so not all damage can be compensated through tort, because even if somebody suffers tort through someone else's behaviour, it could be that the damage is not of the sort that the law is going to amend, because we have to see what sort of damage that the law will intervene about, because we don't want the law intervening about just about everything. Not everything's actionable. So people who claim tort have suffered all sorts of harms, and if the defendant's behaviour was intentional or reckless, that causes damage, then this is recognisable as tort in law. Many people claim that they catch diseases because they've been exposed to injurious substances, but they sometimes say they've sustained economic loss due to negligent advice. People say they suffer psychological illness or harm due to malicious information being spread around. Medical science have meant, and the IT have meant that how harm can be caused has proliferated. There are all sorts of losses that could arise from another person's behaviour, but the law doesn't want to step in all the time. So remember, physical damage to the personal property is usually tortious. Psychological damage resulting from physical harm, or indeed expecting physical harm, even though no physical harm occurs, can also be tortious. Interference with someone's property, including their real property, that's tortious. Economic damage, these things are also tortious. However, the courts don't want to step in all the time. They don't want to regulate every trifling little interaction. This is just part of the vicissitudes of life. Sometimes we have to man up slightly. I know it's a rather unfashionable phrase these days, and just accept these are the slings and arrows of outrageous fortune. That's the way it's going to be this side of paradise. The vagaries of life mean occasionally things will not go quite your way. You'll feel a bit down in the mouth. We need to be a bit more robust and not overreacting to every trifling setback or anyone saying boo to you. We can't have the state trying to govern all our petty interactions. Right, that's enough from me. See you next time. Bye.